Yes, my lords, I was going to move on to the question of breach on exit. On this point, I hope I can be short, and indeed some of the points coming up, I hope I can be shorter on. I think the first two grounds necessarily involve more argument and debate. So far as breach is concerned on ground 2, the position is straightforward, we submit. We say that because the judge wrongly concluded that the metric deal was an exit, for the reasons I've already submitted, it follows necessarily he was wrong to conclude that we breached clause, or the company breached clause 6.2 by failing to give good faith consideration to the metric EOIs. Because if the metric deal wasn't an exit, then the EOIs were not an opportunity for an exit. Now, that's really all, in my submission, I would need to say. I have to say a word about the other point, what I call the subjective question, because that issue stems from paragraph 199 of the judgment, where, as the court knows, the judge says the issue isn't only whether the company performed its obligation. It would have been open to the company, he says, to refuse the deal with Metric if it had been clear on the face of their offer that what they proposed was not in reality an exit. However, that was absolutely not the case. So he treats the question of breach of clause 6.2 as a subjective rather than an objective one, on the basis that asking the question at the time the company failed to consider the Metric proposal, did the company know that what Metric was proposing was not an exit? And we know that's the way the judge was looking at it because he repeats the point in the consequentials judgment at paragraph 36, which is at page 294 of the bundle, where he says the first and most significant point, even if the fact of such a rollover could have justified the company in declining to consider the Metric offer without breaching clause 6.2, in other words, even if that meant it wasn't an exit, that would only have been the case if the company, had known that the offer had that characteristic, and the company didn't. Consequently, it must still have been a breach of its obligations to consider the offer to decline to engage with it. And in short, it's a very short submission, we respectfully disagree whether there has been a breach of an obligation to give good faith consideration to an opportunity for an exit must be an objective question. And if what you're dealing with is not an opportunity for an exit, then there can be no breach. And I take some comfort that that must be right from the way my learned friend seeks to get behind the judge's reasoning in this context, to pick it up from his written argument at paragraph 62, which is at tab 10. Yes, 10. At paragraph 62, the way my learned friend puts it towards the end is, if the company had concluded that what was proposed was not an exit, it could have ceased to give any consideration to the proposal. However, prior to that point, i.e. when the company didn't know, the issue did not arise, and certainly did not excuse the company from giving good faith consideration to any initial approaches. Now, the contractual obligation is not to give good faith consideration to initial approaches, it's to give good faith consideration to any opportunities for an exit capital E. And if in fact, objectively, what is being proposed is not an exit capital E, then there can be no breach. And I'm not sure there's much more I need to say on that. That is our submission on what I've called the subjective question. Now, our submission that the Metric proposal was not an exit has some important consequences. Not only does it mean that the company did not breach the second part of the first phase of clause 6.2, it also means that even if the company breached the first part of the first phase, but not the second part of the first phase, there is no evidential basis for ordering a conditional buyout. and that's what I turn to now under ground 3 of our appeal, which is essentially no prejudice justifying the buyout order. And obviously, if I'm right on grounds 1 and 2, there's no breach and the matter stops there. But the point I'm on now is that even if my learned friend is right on ground, if Mr. Costa is only right on ground 2, if I'm only right on ground 2, then the judge's approach to prejudice and relief unravels. And the reason for that is this. The judge's direction that there should be a conditional buyout, and by conditional buyout I'm effectively referring to the second hearing, was premised on his finding that but for the breach of the obligation to consider opportunities for an exit, capital E, the company would have had 1 or 2 conditional offers on the table by the end of the investment period. And that finding is in turn premised on the finding that the metric expressions of interest were opportunities for an exit. So if the metric opportunities were not the metric EOIs were not opportunities for an exit, that entire line of reasoning falls away. And the reason we say that is based on the way the judge puts it in 254 and following of the judgment, which is at 268 of the core bundle. In 254, if the company had performed its contractual obligation to consider all offers, it would have had at least 1 or 2 conditional offers on the table by the end of the investment period. If it instructed Jeffreys properly, it might have had more. The extent of loss is simply a function of value. There'll have to be a further hearing, 255. 256, it's clear that an initial non-binding offer from Metric, an EOI, was in fact received during the period. For the reasons he set out, which we debated before the short adjournment, I regard this as complying with the requirements in the SHA for an exit. However, the issue to be determined here is not about conditional offers, but about final binding offers. Both experts accepted there'd be an offer process, there'd be due diligence, followed by final binding offers, which may well have been lower than the initial offers. Just pausing there, of course, the final binding offer may have been lower, it may have been higher than the initial offer. Of course, there may not have been a final binding offer at all, depending on what the due diligence throws up. The question to be determined at the quantum trial is therefore at what level an offeror who had done proper due diligence would have pitched their final binding offer, assuming, of course, that there would be one. So the starting point is the reference to the company performing the obligation to consider all offers. That paraphrases the second part of the first phase of clause 6.2. But the only way in which the company was found to have breached that obligation was in relation to the metric expressions of interest. They're the only EOIs the company received in the investment period. So the reference to having 1 or 2 conditional offers on the table by the end of the investment period is a reference to metric. It may be that the 1 or 2 comes from the fact that metric submitted 2 EOIs, but I'm not sure that makes too much of a difference for present purposes. And this is confirmed by the approach in 256, where the learned judge recognises that you can't simply take the value of the metric EOI as a measure of Saxon Woods' loss or the prejudice for these purposes which they suffered, since they're only initial offers, and any final binding offer, if there was one, could have been lower. And that's why it was necessary to have a quantum trial rather than a further trial, and he didn't deal with that in this initial trial. Now, therefore, as we say, if we're right on ground 2 that the metric proposal was not an exit, there is then, as I say, no basis for the finding that there would have been 1 or 2 conditional offers by the end of the investment period, and therefore no basis for ordering a buyout conditional on the final versions of those offers. Now,
is the quantum trial only to determine what offer would have been made by metric? That's not right, is it?
no, exactly. There is. I'm going to come to this a little bit later. When my lord said yesterday that the quantum trial is really a causation trial, essentially, with respect, we agree. I mean, really, it's to decide, has anything come from any breaches?
Well, the way the judge put it, it seems to be, because it has to be an offer over a certain amount.
Yes, exactly. So in the real world, would there have been an offer over a certain amount? 75
Had your client not breached not just the second sentence of 60, but also the first sentence?
Yes, yes, absolutely, absolutely. And I'll come to make submissions on that, but certainly it's not. I think we can all agree that when one looks, and I'll come in a minute to look at the ICC Judge Burton order, which ordered the split trial, what the learned judge has put into trial 2 goes well beyond what Judge Burton anticipated would be in trial 2. But we are where we are. Obviously, the judge has got jurisdiction to do that. I'm not saying he can't, but my lord is right. Now, just to finish off this point, my learned friend says in his written argument that the metric EOIs were not the only basis for the judge's conclusion that there would have been 1 or 2 conditional offers by the end of the investment period. That's at his written argument at paragraph 72. But when one goes back to that, the only other basis he can point to is a confirmation in the expert reports that there was enough time to achieve a sale by 31st of December 2019. Well, and there were 2 problems with that. First of all, that point in the expert reports doesn't make its way into the judgment, so it's not a finding, point 1. Point 2, more importantly, it doesn't follow from the fact that there is sufficient time to achieve a sale that offers would have been received and would have been made. And indeed, what we know from the facts is that from March 2019, Mr. Loy had decided that he needed to go out and find buyers independently of Mr. Costa, and doing the best he could, the metric deal was all he came up with. And that's despite the fact that, as the judge found at paragraph 233 of the judgment, Mr. Loy's preference was actually to exit the company altogether. And all he could come up with was the metric deal in which he didn't exit the company altogether, goes back to the earlier discussion we had. And therefore the idea, just standing back, that there were or could have been other offers out there which were missed is fanciful. But certainly I do stand on the basis that the judgment records no other basis for the finding that there would have been 1 or 2 conditional offers on the table other than the metric offer.
Can I just wind back a second? You've since lunch, since we started again, you've been stressing the point that the metric offers were not exits as defined. I mean, I thought, at least I read the judgment as suggesting that the judge's findings of breach went further than just not having anything to do with the metric offers, such that if you were right that they were not exits, it doesn't mean that there wasn't a breach. Am I wrong in that?
He finds breach of first sentence and breach of second sentence. The point I was making is that the breach of the second sentence in my submission is only based on metric being an offer. Being an exit, sorry.
Because I mean, I think, right, so...
And my point is, if there's a breach... Sorry, I didn't mean to interrupt, my lord.
No.
But if there's a breach of the first sentence, in other words, if my learned friend is right, so to speak, on the first sentence, but I'm right on the second sentence, my point here is that the judge's finding that there would have been other conditional offers, that is only based on his finding a breach of the second sentence. And so if I'm right on that finding that there would have been other conditional offers falls away. That doesn't flow from his finding a breach on the first sentence. That's the point I'm making.
Does there need to be a finding that there would have been other offers to kick it to a quantum trial? I mean, if the judge is right and there was a breach of the working together towards an exit, which I think is what you mean by the first sentence.
Yeah.
Right. So in other words, the breach isn't tied to not engaging with the metric offers, but is a breach of the first sentence. Are you saying that there's no basis upon which any experts could find that if the contract had been performed according to its terms, some offer wouldn't have been found?
I can't put, of course I can't put my case as high as that. What I can say is, I would repeat the point I just made, which is that's certainly not the way the judge approached it, and certainly that would involve reconfiguring the counterfactual assumptions or the assumptions which are given to the experts for the purposes of the second trial.
Okay, so what you're saying is you might have to accept that if we uphold the judge on what I call breach of the working together towards an exit,
Yes.
it would be open to, it would be appropriate to have a quantum trial, but on different parameters. And the experts would have to give a view as to whether that would have led to, or could have led to an offer at, and perhaps value the loss of a chance?
Yes. Can I preserve my other grounds for appeal by agreeing with the substitution of the word may be appropriate rather than would be appropriate to have a second trial?
Certainly.
Because there are other factors going into that mix. But certainly, what I can't say is that if I lose on ground one and win on ground two, there is no universe in which the court couldn't consider that a second trial might still be appropriate with different parameters. I can't put my case that high. That would be somewhat unreal. I hope that answers my Lord's question.
It does. Thank you.
Now, that's my argument on the assumption that I have lost on ground two and have lost on ground one and won on ground two. That's the exchange we've just had. I do have this point, which is an independent point. It's a very short point. Even if I'm wrong on ground two and metric was an exit, I do make this submission, it's a very short submission, that a buyout order is still not an appropriate form of relief in these circumstances, because what we now know was that even if the metric deal was contractually an exit for the purposes of 6.2, in reality, Saxon Woods and Mr. Loy would not have exited smally from the company because of the rollover, as I'm calling it. And since it would not have been bought out had the unfairly prejudicial conduct not occurred...
Sorry, can you just, for me, I'm sure,
Sorry.
not others, but can you just go back 2 sentences?
Yes.
Even if...
I'm assuming here that the metric deal was contractually an exit.
Yes.
In reality, in the real world, my submission is Saxon Woods wouldn't have small e exited, it wouldn't have left, because in the metric deal, Saxon Woods is rolling over.
Right.
Yeah? Saxon Woods is rolling over in the metric deal.
Okay.
Yeah? So, since it would not have been bought out, had the unfairly prejudicial conduct not occurred, because it would have still have been in the new vehicle, it's a very short submission. We submit that it's contrary to equity to grant relief in the form of a buyout order. That's a very short submission. And essentially, because the thrust of the judge's approach is that because of our conduct, the petitioner was unable to sell the shares at the price he would have received had not COVID intervened, picking it up from judgment at 265. In the metric scenario, in reality, Saxon Woods wouldn't have been selling its shares. It would have rolled over its equity. So my primary submission is, if I'm right on 6.2, sorry, if I'm right on the exit point, then there is no. If I'm right, let me get this clear. If I'm right on 6.2 ground 1 and ground 2, that's the end of it. If I'm right on 6.2 second sentence, i.e. the metric proposal was not an exit, but there is a breach of the first sentence, then we say, as the judge found it, there is no basis for considering there would have been any offers. And then that ties into the point put to me by Lord Justice Snowden, but the court might still order a second trial, but on a different parameter. And we say also, though, that in any event, this is the very short point, a buyout order is still not an appropriate form of relief, because in the real world, even if metric was a capital E exit, Saxon Woods would not in fact have been bought out. They would have stayed in. That's all I was going to say on ground 3. Ground 4, I hope I can take relatively quickly, because these are the counterfactual assumptions for the quantum trial. And the central point we make here, which really runs through all of these submissions, is that if we're wrong on any of the contractual breach points, such that the court thinks that there should be what I'm calling a conditional buyout order, and therefore there should be well, we're calling it a quantum trial, but it's not really a quantum trial. In those circumstances, we say the learned judge erred in the assumptions he makes for that quantum trial. And the error arises partly because the learned judge considered what he thought the company should have done rather than what Mr. Costa should have done. Now, that wouldn't be a problem if the buyout order was against the company, but of course the buyout order is against Mr. Costa personally. Now, we don't challenge the fact that the judge made the order against Mr. Costa personally. Indeed, Lady Justice Aspelin expressly prevented us from challenging that. So we don't. But we do respectfully submit that that means that the counterfactual scenarios should be limited to points over which it's fair and equitable to hold Mr. Costa personally responsible. And that's our first point. The second point is we say there are some points really where the counterfactuals shouldn't be in the quantum trial, regardless of whether the order is made against Mr. Costa personally or the company. Now, the parameters of the counterfactual scenario are set out in the judgment at page 259. And the first one I want to take is 259 Roman 2, which is that the company should not have paused the marketing process while the search for a new CEO was ongoing. This is incompatible with the idea of a good faith attempt to obtain offers by the end of 2019. Now, whether it is or is not incompatible, we debated earlier. I'm not going to go back over that ground. But for present purposes, the point is that the decision to pause the marketing process can't be laid at Mr. Costa's door, nor was, as I submitted earlier, that decision incompatible with the obligation under 6.2. The decision to pause the marketing process was taken by a unanimous board resolution, including Mr. Loy, on the 28th of February 2019. That's at the core supplementary bundle, tab 9, at 43 to 44 of the bundle. I think we looked at this briefly yesterday. Exit, it's CSB/43, which is behind tab 9. Exit process update. Chairman informed the rest of the board. Jeffries, after almost a year, is ready to go ahead and work along with Spring, prepared marketing materials. They trust the CFO, only waiting today's BOD to approve the 2019 budget and the Q1 numbers. After that, they can market the company. Chairman explains happy with the overall trends. company is ready for the new CEO, who will take Spring to the next chapter and prepare the company for the exit process as contemplated in the Investors Agreement. For AO to get the best investors, you need consistency in financials and a great CEO. For FC, it's important to have Ernst & Young bless the financials, even if it's expensive, goes through Mr Flamini, and then a resolution to circulate Jeffrey's engagement letter, pursuant to which Jeffreys will commence the exit process as soon as the new CEO is identified. Now, the judgment doesn't refer to that critical point. Indeed, the judgment doesn't refer at all to the decision to pause the marketing process until the counterfactual parameters are set out here. This is the first reference in the judgment to pausing the marketing process. But what the judgment does record at paragraph 46 is that even in March 2019, i.e. a month later, the review of all concerned was that the sales process was capable of being completed within the year, and that the sensible course of action was to wait for the CEO to be appointed. And again, I'll just give my lords the reference, but for what it's worth, Saxon Woods expert also regarded the decision in February to delay the marketing until after the CEO's appointment as being reasonable. That's, I'll just give my lords the reference, Core Supplementary Bundle, tab 45, page 243. And so there is no basis for the judge's statement that pausing the marketing process was incompatible with the idea of a good faith attempt to obtain offers by the end of 2019. All of the board, including Mr Loy, were familiar with clause 6.2. Nobody had any, Mr Costa didn't have secret knowledge. They all agreed, knowing that, to delay Jeffrey's work until the new CEO was in place, because they all believed that a sale could still be done by the end of 2019. Now, the judge does come back to this in the consequential judgment. He seeks to shore up his reasoning on this point in paragraph 41 of the consequential judgment, which is at page 296 of the core. And I'm not going to read it out, but there are, and this is echoed by my learned friend in his written argument. The reference is his skeleton paragraph 77. But there are three problems with the approach of the judge in 41, which don't get him out of the problems I've identified so far. The three problems is, first, the decision to pause marketing in February 19 cannot have been a breach of the company's obligations when everyone thought a sale could still be completed during the year. The fact that they turned out to be wrong is irrelevant. At the time the decision was taken, there could not have been a breach of the obligation to work in good faith towards an exit. Secondly, and importantly, the finding that Mr Costa had misled the board, the reference for that is the judgment at 202, does not apply to the February 2019 board meeting. That follows from a finding that Mr Costa and Mr Uberoy were the two who were engaging with Jeffreys. They were the only ones, therefore, who knew both the scope of Jeffrey's mandate and also the terms of 6.2. And essentially, the judge held that they misled their fellow directors by giving the impression that what Jeffreys was doing was working towards an exit no later than the 31st of December 2019. But that's got nothing to do with the February 2019 board meeting. As I've shown the court, at the time of that meeting, the board knew exactly what Jeffreys had been doing and what it was proposed to do in the future. And there is no finding, rightly no finding, that what was presented to the board in advance or at the February 2019 board meeting about Jeffrey's work was in any way wrong or misleading. And following on from that, and my third point, there is no causal link between the board being misled as to the scope of Jeffrey's work and the resolution to pause the marketing process, not least because Jeffreys hadn't even been mandated to do anything by this point. The engagement letter was only signed in June. If, for example, the board had been misled by Mr Costa at the February 2019 meeting as to how long it would take to get a new CEO on board, then there would be something in the point. But there's no finding of that. There's no misleading on that basis. So the first point is that the counterfactual, going back to 259, the counterfactual of a pause in the marketing process not taking place, i.e. there's no pause in the counterfactual, is a wrong element of the counterfactual, because even if Mr Costa had not caused the board, the company, to breach its obligations under 6.2, which is the hypothesis we're dealing with here, the board would still have made this resolution in February 2019. That's the first one. The second one is Roman 3, the instruction to Jeffreys that it was required to seek offers by the end of 2019. And the purpose of this counterfactual is to cure the company's breach of the first part of the first phase of clause 6.2. So obviously, if I'm right about that, then there's no breach of this in the first place. But even if I'm wrong on that point, i.e. ground 1, there's no place for this counterfactual we submit for 3 reasons. First of all, and the point I've already made, there's no finding and no basis for any finding that had the company not breached the work towards an exit in good faith obligation, other offers would have been received. That's the metric point, which I've already made that point. Second, even if the court was to find that Mr Costa's construction of the work together in good faith obligation is wrong, it doesn't mean that the learned judge's construction is necessarily right. And Saxon Woods' case is that the judge did not conclude that clause 6.2 meant that the company was required to procure offers by the end of 2019. And therefore there shouldn't be a counterfactual which requires that, i.e. the company should have instructed Jeffreys it was required to seek offers by the end of the period. I accept that point and my first point to some extent, such that point ties in with my overall submission on ground 1. The third point, however, is that even if the company was required to instruct Jeffreys to get offers, there's no evidence that anyone in the company thought that this was what was required at the time. Now that's an important point. It wouldn't matter if the buyout order was against the company. But it does matter, in my submission, in circumstances where it's sought against Mr Costa personally, because the effect of it is this. It places what we say is an unreasonable onus on an individual director to do something which at the time none of his fellow directors appeared to think necessary. No one protested, for example, that Jeffreys' mandate, as contained within the engagement letter which they saw, should state that they were required to get offers. And so, in circumstances where the order is being made against Mr Costa, in circumstances where none of this crossed the company's mind, it is an unfair counterfactual in a quantum trial against Mr Costa personally. So those are the various reasons we take issue with the third counterfactual. The last is a fourth counterfactual, the consideration to the metric offer. Now, obviously, my primary submission is the one I've already made, which is that the metric offer is not a capital E exit.
Sorry, can I just retreat for 1 second?
Yeah.
If a company breaches a contract, there's no reason to investigate beyond the question of whether objectively what it did or didn't do was breach the contrary to the terms of the contract. Why should it matter what Mr Costa actually thought if he was the person who had responsibility within the company for whether the company complied or not? It's that last bit.
Yeah.
So, I'm sorry, I'm just trying to keep pace.
No, sorry. Well, I hope I'm not going too quickly, but equally I didn't want to go too slowly.
No, sorry. Lady Justice Hell once told me you have to go at the pace of the slowest boat in the convoy. So
yeah,
that was good advice.
Yes.
So can you just slow down for a touch for me?
I will. I'm conscious that in this course I might have 3 speedboats, but
I feel like you've got sort of a tugboat at the moment at this end of the bench. But
Okay, we'll move away from the nautical metaphors. In circumstances where the company's breach is attributable only to what Mr. Costa's done, and in some circumstances where the buyout order is made against Mr. Costa personally, I would respectfully accept the thrust of the point my lord is putting to me. However, when it comes to the company should have instructed Jeffreys, it was required to seek offers by the end of the period. The entire board saw the engagement letter. The entire board has access to clause 6.2. The fact that the engagement letter doesn't mirror the terms or include the terms of 6.2 is not something which can reasonably be laid at Mr. Costa's door alone. And in those circumstances, it's wrong to say, my respectful submission, that the counterfactual should assume something which wouldn't have happened even if Mr. Costa had acted properly.
That's the unknown, isn't it? We don't know it wouldn't have happened.
Well, the evidence we have is that there's no evidence that the only reason the board didn't pick up this discrepancy is because Mr. Costa said, don't worry, it doesn't matter, or anything like that. They had the engagement letter, they had the contract.
Would you not have to go so far as to say, and you may say this, but you do say this in relation to the February meeting, the board as a whole, with full knowledge, voted for a course of action. Therefore, the counterfactual can't include something which the whole board, ignore something the whole board decided on.
That is essentially what I'm saying.
But later on, you don't have the same evidence, do you, that the whole board decided to act in a way which was consistent with Mr. Costa's view?
I don't have it in the sense of a positive document. What I have is the facts and the obvious implication which I seek to draw from them. But I absolutely accept, I don't have, for that second point, the same look at this piece of paper and here's a resolution in terms that I do for the February 19 meeting. Now, I was, just to pick up my submissions on the fourth point then. Two of the 3 points I've already made, and therefore I'll just mention. The first point, obviously, is we say the company had no obligations in respect of Metric because it wasn't a capital E exit. The second point is it still shouldn't form part of the counterfactual because in reality, Metric, under the Metric proposal, Saxon Woods wouldn't in fact have exited anyway. I've made both of those points before. The third point in relation to Metric is that Jeffreys' advice to the board was not to engage bilaterally with Metric. And as essentially with the previous counterfactual, this counterfactual really requires Mr. Costa personally to go out on a limb and act against the advice of the company's advisors. So if the court is with me that there was no breach of the work towards an exit obligation, i.e. the second sentence, but, the first sentence, but against me on the question of breach of the obligation to consider opportunities for an exit, there's no basis to think that Jeffreys' advice as to how to do that exit would have been any different in the counterfactual.
I just ask, the judge found that Jeffreys weren't aware of the obligation to work in good faith towards an exit by the end of 2019.
Yes.
So when they gave this advice, they weren't aware of that.
They weren't aware of that. They weren't aware of that. But their advice what wasn't a timing point. Their advice was don't work bilaterally with Metric. Now, it may be that where we get here is somewhere close to the point Lord Justice Snowden put to me earlier. In other words, if I'm right on some or all of this, it may be that there's still another hearing, but we need to tweak the counterfactuals a bit. And what I certainly accept is that there is an obviously very close relationship between these counterfactuals and the conclusions the court comes to on what the contract means and whether there was a breach. And I mean, there are so many permutations of that. It's simply going to be impossible for me to deal with all of them. But I hope the court at least has seen my submissions and understood my submissions on 259 Roman 2, 3 and 4, and perhaps more importantly, the reasons why we make those submissions, because it may well be, depending on where the court ends up on ground 1 and ground 2, either this court or a judge in the Chancery Division would need to consider what are the implications of this court's decision on any quantum trial. Is it we have the quantum trial with the same counterfactuals, or with different counterfactuals, or some other? That is the end of the first part, in the sense of that's what I was proposing to say on my appeal. So I'm now moving from presenting my appeal to responding to my learned friend's appeal. I'm going to deal with the points, I hope, in the same order. First, I'm going to deal with the director's duties points, which are my learned friend's grounds 1 and 2. There is an introductory point here, which is, in my respectful submission, a really important one, and I would like to take just a couple of minutes on it. The genesis for this is a question which my Lord Justice Snowden asked at the beginning of yesterday, which is, how are these breaches relevant to the overall appeal? And the answer given was that these are freestanding grounds of unfair prejudice. Now, I think that was later revised essentially to section 172 being a ground of freestanding prejudice, since on 174 my learned friend fairly accepted that that is not a particularly strong ground itself for unfair prejudice, and would really be a contributing factor in the analysis of the appropriate relief should a breach be established otherwise. Now, it's fair to say that on this side of the court we were a little surprised to hear that 172 is being advanced as a freestanding ground of unfair prejudice, because in my learned friend's skeleton for this appeal, the breaches of directors' duties are said to constitute a further ground of unfairness, justifying relief in the form of buyout, i.e. it goes to unfairness, not the prejudice itself, and justifying relief in the form of a buyout against Mr Costa personally. That's my learned friend's skeleton at paragraphs 29 and 40. Now, that is also how it was put in the petition too. And if we just pick up the petition, which, as my learned friend said yesterday, is a very long petition and goes through, I think, the whole gamut of colours for amending and re-amending. At paragraph 70, and then over the page at paragraph 71 of the petition, which are...
Just going back, sorry. I mean, I know you're going to take the petition, but you're saying, you're reading paragraph 29 of Mr Davis's skeleton, and you're saying, haha, he doesn't use the word prejudice. Is that it?
This really isn't a ha-ha point. I would say that we certainly understand that my learned friend now is running this as a separate ground of prejudice point. Absolutely.
Yeah.
What I didn't understand that from the skeleton. I want to take you really to the petition.
Okay.
And the petition and how it was put. Now, just to be clear, I'm going to be dealing with the point in any event, because we're in the Court of Appeal and 172 is important. I'm going to deal with it. I just want to put it into context. At paragraph 70, and then over the page at paragraph 71, we have breach of contract, and then particulars of breach at paragraph 71. I'm at 331, 332 of the bundle. And the consequences of breach is where Saxon Woods pleads the causal link between the conduct complained of and the prejudice said to be suffered. I'm not going to read it out, but you can see that. Immediately after that, you see, and that's at 72 headed consequences of breach. But for that conduct, an exit would have been achieved. immediately after that, the same structure is followed to the in relation to the breach of contract alleged under the second phase of clause 6.2. Now that's not relevant to these appeals, but you can see that there is a heading breach of contract of 6.2. There's a long narrative section which goes on for many pages. In fact, it takes you all the way through to 351. All of that is narrative. And then at 351, right at the bottom of the page, there's a heading breaches of contract by the company, which is followed by the particulars as before, 130, 131, 132, and then consequences of breach, where causation again is pleaded. As a result, an exit wasn't achieved as soon as reasonably practicable. Then the petition moves on to breaches of duty by Mr Costa. Now, if these are independent breaches giving rise to the same conclusion, one would expect the same structure to be followed, but it isn't. The 172 case is set out in the particulars underneath 135, which is on page 354, and 1 and 2, subparagraphs 1 and 2 are relevant for these purposes. Subparagraph 3 is a conflict, separate conflict point. And it's clear when one reads those subparagraphs that Saxon Woods is alleging that the breach of section 172 amounted to unfairness. But there's no section on the consequences of a breach of 172. The petition moves on to 174, and there's no consequences on the consequences. There's no section on the consequences of that breach either. And you can see that because at 357, the petition moves on to breach of Mr Loy's right to information as a director. So certainly so far as the petition is concerned, it seems that the alleged breach of 172 is not freestanding, it's parasitic on a breach of clause 6.2. It's the breaches of the contract which are said to have caused the prejudice, and on Saxon Woods' case, it simply follows from those breaches of contract that Mr Costa also breached his duties as director. Now, that would mean that with one exception, which I'll come to, which I need to deal with, if my first and second grounds of appeal succeed, we will submit that the first and second grounds of learned friends appeal necessarily fail. The exceptions...
Why do you say that a breach of fiduciary duty by a director is not of itself prejudicial?
Well, I'm going to... Can I come to that point? I will come to that point.
I think that's what you just submitted.
I've submitted that in this case, if there's no breach of the SHA, there's no breach of directors' duties. It's not Mr.
That's not. I don't think that's quite the question I asked.
Right.
I mean, you may be right.
Yeah.
You may be wrong. I don't know, but. If I've understood what you've just been submitting by reference to the way the petition is pleaded, you say that because there were no consequences pleaded following on from the allegation of breach of fiduciary duty, ergo, the petitioner is only saying that the breach of fiduciary duty was unfair, but no prejudice, therefore can't ground relief. Is that right?
Yes, that's where it's pleaded. Now,
right, okay. Well, because there are no consequences pleaded, you say it must follow that the petition doesn't allege prejudice, something which could amount to prejudice under 994.
Yeah. Yes. And
so you are saying that this is locking into the point that in order to be unfairly prejudicial conduct, there has to be
some
conduct which has financial consequences.
I don't want to go quite as far as that as a matter of general proposition, because I accept, we'll come to the, we looked at the decision of Mr Justice David Richards in Zacaroli, etc. You can have prejudice or consequences which are not financial, but it's much harder to get home on those if they're not financial. In this case, however, what's said in
Could
terms...
actually be very straightforward.
Sorry?
It could be very straightforward. You know, as I said to you, I mean...
the misleading the board point?
Well, or, you know, just... yeah, I mean, appointing... I mean, we talked about appointing directors or breaching some agreement or understanding in circumstances where that's not something directors should be doing and they're doing it for improper purposes, for example, but nothing has come of it as yet, but it's the mere fact it's happened. I mean, that's got to ground relief under 994, or else the court would have to wait until, you know, the new board did something dreadful causing loss, and that's quite clearly not what 904 requires.
Yeah. I'm going to pick, if I may, I'm going to pick that point up, and I come to the point of misleading the board in the context of 172. And I'll try and pick that point up. I certainly am not saying that there were no circumstances in which a breach of fiduciary duty could not ground a petition.
Okay.
I think that would put it too high, which is the point my lord is putting to me.
It is, because I was wondering whether that really was what you were doing so smoothly. I just couldn't detect whether I'd already sort of bought that.
In circumstances where, let me make this point, because this is also relevant. What we will certainly say is, in circumstances where the court finds, contrary to my submissions, that there is a breach of contract, especially given the way this case has gone and the way the petition is phrased, this court should be slow to find a breach of fiduciary duty, because we've accepted, for these purposes, that a breach of contract is going to get my learned friend into the, into the sweet shop from yesterday in any event. This point really only arises if my learned friend loses on ground 1 and ground 2, and the only way he gets into that sweet shop is the breach of fiduciary duty.
Correct.
Yeah. So let me first underline that point, because that's obviously important for Mr Costa. So the first point which I do underline is this court shouldn't start finding breaches of fiduciary duty, especially given the way the case has been put until now, in circumstances where it really isn't necessary, because the learned friend's in the sweet shop anyway. We do go on to say that in this case, we do say if I'm right on grounds 1 and ground 2, because of the way which I'm going to make my submissions on 172, there shouldn't be a breach of 172 in any event, and 174 is not really relied on as a separate ground for these purposes. So that's really where we get to, and I don't think I need to take the court to it, but let me just give the court the reference. In Rock Nominees, which was referred to yesterday, that's Authorities 19 at 375, the judge had found that the manner in which a sale had been conducted did amount to a breach of fiduciary duty because the directors were in a position of conflict, but found that the sale had not been at an undervalue, so there was no prejudice and no basis for relief. To pick up Lord Justice Zacaroli's point, essentially, it didn't go anywhere. There was no causative effect. The Court of Appeal upheld the decision to dismiss the petition on the basis that the sale wasn't at an undervalue, and they allowed a cross-appeal against the finding of breach of director's duty, and essentially said, in a section beginning at paragraph 79, the court should be slow to find breach of fiduciary duty in circumstances where it really doesn't go anywhere. And the Court of Appeal in Rock Nominees reversed the finding of breach of duty, even though it made no difference to the final result. It would be a fortiori, my respectful submission therefore, in circumstances where a finding of breach of duty wouldn't make any difference to the result, i.e. if we're wrong on the contract anyway. So if we're wrong on the contract anyway, we do respectfully submit that the court should not really be interested in the breaches of the fiduciary duty per se, because it doesn't materially advance the debate. Now, I appreciate that what I've said for the last 5 minutes, the court may say, well, that doesn't really help us determine the appeal. Of course, these are very important points in the real world for Mr Costa personally. Let me now turn to section 172. The duty to promote the success of the company for the benefit of its members as a whole. Now, we say, in short, and my submissions on this point really are short, I hope, the judge applied the correct legal test. He made findings of facts, and it's not open to my learned friend essentially to challenge the factual findings made on the application of the test. Now, let's start with the test. I think we both agree, my learned friend and I agree, with the learned judge. This is paragraph 20 of his written argument, and it's the judgment, more importantly, at 207, that the test is that set out in Regent Crest, which the judge sets out at 207, at page 250, starting with the 4 words, the duty is subjective, with which we respectfully agree. And he sets out the well-known and oft-cited passage from Regent Crest per Jonathan Parker, Mr Justice Jonathan Parker, as he then was. Now that is the test the judge applied.
I mean, just to be clear, there is usually a slight gloss put on that, which is there is a sort of objective flaw, F-L-O-O-R, to the duty, I think, and that comes from a number of other cases, which are out of my head at the moment, but mainly to deal with directors who are just subjective, just really stupid. Or at least, but it may sometimes be that even if you subjectively believe, you may still be in breach of fiduciary duty if essentially no honest and intelligent person could have believed it. And it may be, on one view, that would lead to the court not believing your evidence as to what you subjectively believed. I think it's occasionally said there is actually a sort of objective level below which you also just can't go. But for present purposes, we're not in that territory.
Yes, exactly. I wasn't seeking to dodge my Lord's point, but that was going to be what I was going to say. For present purposes, we're not there. I would certainly accept and underline this point, and this is a very important point, which is, as part of what my Lord just said, whether there is an objective flaw or not, and we, as I say, we can park that for these purposes.
Yeah.
Clearly, and this is what's sometimes referred to as the last sentence of Jonathan Parker, Mr. Justice Jonathan Parker, although here is actually the penultimate sentence. Clearly, the odder and the weirder and the less likely it is that somebody honestly believes something, obviously plays into the question whether the judge will accept that that's what they honestly believed. Now, actually, that point we don't have in that quote. Let me show the point. Let me show the court that point in Regent Crest, just to make good what I've just said. Regent Crest is in the authorities bundle at tab 15. And if we pick it up at paragraph 120, oh, sorry, page 309 in the authorities bundle. Sorry, Mother. And the court will see that what the learned judge has done in 207 is repeat 120 up to the issue is as to the director's state of mind, just after C. The point I was referring to, which is the next bit, no doubt, where it is clear the act of omission resulted in a substantial detriment to the company, the director will have a harder task persuading the court he honestly believed it to be in the company's interest.
Sorry, can we just retreat for a second on this? This starts by saying the duty imposed on directors to act bona fide in the interests of the company.
Yes.
Now, I'm just going to, just wanted to get into semantics about this, but that formulation to act bona fide, for which can we just use English, good faith, rather than bona fide, but let's just use it because it'll make the point easier for me to make. The duty imposed on directors to act in good faith in the interests of the company is a subjective one. Now, the way it's translated into Section 172(1)(a) of the Companies Act is a director of the company must act in the way he considers, in good faith, would be most likely to promote the success of the company. I've always rather understood that there is an overriding duty to act in good faith, i.e. honestly. And the question of what you consider to be in the interests of the company is a subjective element. So there is, and it may be this does become relevant in the instant case.
Oh, it does. Absolutely. It's a point my Lord put yesterday, actually, if I may say.
Yeah, well, okay, well, the consistency is good to hear. The question of what the director believes to be in the best interests of the company is a subjective one. It's not what the court thinks.
Yes.
Provided the director subjectively believes that what he's doing is in the interest of the company, then he's performing his duty to the company to act loyally, if I put it that way, in the general fiduciary sense. But the question of whether he's acting in good faith is a broader one. It doesn't go to a state of mind. He must act honestly in what he does. Now, is that right? Because that's the old formulation.
Exactly.
And it's one way of reading the new formulation, but if you say it's purely subjective, if 172 is purely subjective, then you rule out the possibility of good faith and honesty, which is, we know, objective.
My Lord,
you know where we're...
I know, if I may say, with respect, I know absolutely where you're going, and this is the point, if I may say, you, my Lord, mentioned yesterday, when my Lord said, so to speak, I think the example was, if you're lying to the board, how can you be acting in good faith?
Correct.
That's a short, if I may say, that's a short way of putting that, as another way of putting that point.
Yes.
I will be dealing with that point.
Good, because of course here it's said against Mr Costa, he lied to the board.
Absolutely.
Subjectively believing
exactly
he was doing his best for everybody.
That's
why it's important to get this formulation of the reading of Section 172(1)(a) and the reading of Regent Crest, for example, which predated the Companies Act 2006, correct?
Yes, absolutely. And I don't want to sort of give away the denouement of my novel before I get there. But essentially, I will
always turn to the last page anyway.
Exactly. I will be saying that the test really is subjective, and when it says this is subjective, it really means this is subjective. And I'll seek to make that point good. But I respectfully agree with my Lord that that is likely to be the pivot on which the 172 argument will ultimately turn for this case, with respect. Can I, as part of that, though, and this is important for my argument, can I invite the court really to look again, I can't remember whether I read it out now, the bit under C. I think I did, yes. In other words, if you're acting in a way which most people would not regard as honest, or acting in a way where you're causing substantial damage to the company, you're going to have a harder time, and perhaps an impossible time, in front of a particular court, in persuading the court that you honestly believed it was in the company's interest. But, critical point at the end, that does not detract from the subjective nature of the test. Now, just to, if I can develop the argument first by reference to what the judge did. We respectfully submit that what the judge did at 207 and 208 was to apply that test. And importantly, where the judge concludes, I think his state of mind might be summarised as, they wouldn't like it now if they knew, but they will thank me in the long run. Put another way, I think Mr Costa did sincerely believe he was acting in the best interest of the company and its investors. We submit that that factual conclusion as to what Mr Costa subjectively thought, what his state of mind was, is a question of fact, and that is it. And Malone Friend is stuck with it. And Malone Friend can't get round that, just to pick at this point, by stating, as he does in his written argument at paragraph 29, that Mr Costa's conduct constituted a breach of duty as a matter of law. That is a very nice forensic sleight of hand, but it is a forensic sleight of hand. Because once you identify that the legal test requires you to examine the director's subjective beliefs, what those subjective beliefs were is entirely a question of fact.
Right,
now,
but I mean, you are now skipping round the question of...
I'm coming to that. I'm absolutely coming to that question. But the reason why I need to do it this way, if I can, I'd like to do it this way, is because I want to underline, want to show the court how the subjective nature of this test has been underlined in subsequent authorities. Because what my...
Okay, but if the judge said, I think his state of mind might be summarised as, they wouldn't like it now if they knew, but they will thank me in the long run.
Yes.
But embedded in the first part of that sentence, they wouldn't like it now if they knew, I think is the judge's finding, but I'm not going to tell them.
Yes.
But they'll thank me in the long run. And
yes.
So the question is, can you be said to be complying with your fiduciary duties, not to tell them?
Yeah.
You know, so in other words, you act in a way which objectively would be regarded as not in good faith or dishonest, which we know is an objective test.
Yeah.
You can't set your own standards of honesty. Albeit that subjectively you think that misleading the board will be better for everybody in the long run. So
yes.
Hidden within that formulation is, I think what Mr Davis says, is a finding that, in essence, the board was misled, or that there is a breach of fiduciary duty, because objectively speaking, people are not supposed to lie to the board. You know, they are supposed to tell them. You know, so in other words, they should know.
Yes. Just to be clear, as I understand it, my lord is putting to me the same point, essentially. Yeah, exactly.
I am, because I feared that, as all good advocates do, you're trying to sort of start us off by looking at this as if it's solely formulated by reference to a state of mind. Subject to state of mind.
I absolutely no. I absolutely wasn't. I wasn't. It's no part of my argument that the judge doesn't find, for example, that Mr Costa misleads the board. It's no part of my argument on this point. It's no part of my argument to say misleading the board is something which directors shouldn't do, and if you're acting in good faith, you wouldn't do. But for the purposes of this part of the argument, I'm accepting it, because those are my lord's premises for the question my lord is putting to me. Yeah. My argument on this is this, and I'll take it this way around. I did want to show the court the cases, and I'll just give the court. Shall I just give the court the references?
Lord Wolfson, I think we need to have a break, don't we, for the transcript? I'm sorry to interrupt you in the flow, but I think this is probably the right moment for it. So we need to have 5 minutes.
I'm grateful. Thank you.
And then we can come to that.
I'm grateful.
Thank you.
Exactly. I think I should mention. Exactly. And then essentially, we want to go to E on 278 on 78.
Yep. And then I do think H is important.
Yeah, although I think also we need to pick up the language point of 172.
Yeah.
So I'll pick that up. Why? Because isn't it? He must act in good faith in the way he considers to be. Isn't this way he considers in good faith? Where did we want to get to? 93.
Yep.
Well, I should be able to do that. I might even be able to do a bit more.
I was thinking you might actually.
Well,
Got that reference.
Sorry, we should have banged the door. Sorry. Thought somebody had. Sorry. Yes, and to save time and to make sure I'm not avoiding my Lord Justice Snowden's question, can I give the court 2 references from the authorities and explain why we ask the court to look at these paragraphs, where the court has what counsel laughably referred to as some spare time. Recaroyne is the first. Decision of Mr Justice David Richards then was, its authority is 28. The paragraphs we'd like the court to look at are 567 to 569. And the 2 points we seek to get from that are, first, in 568, where the learned judge refers to Mr Faber that he, quote, genuinely believed the rights issue was in the best interest of the company. The genuine belief is another way of saying considered in good faith. It's another formulation, and we say that is what the judge meant when he was talking about Mr Costa's sincere belief. He's added a gloss of an adjective. The real question is whether the director honestly, sincerely, genuinely, they all mean the same thing in this context, believed that what he was doing was in the best interest of the company. The second is the learned judge's point at 569, which is that it is not enough to show that the decision taken, in that case the rights issue, could not reasonably be seen as likely to promote the success of the company, i.e. an objective question. You've got to show the director also subjectively didn't think it was likely to do so, or didn't honestly think it was likely to promote the success of the company. That's a point which I've made already. The second authority is Last Line Holdings, authorities 35, paragraph 124. It's a useful decision because it sets out that the court won't inquire objectively whether the decision was or was not the best decision for the company, or whether the director's belief was reasonable, makes the point that if no reasonable director could have concluded it was in the interest of the company, it's unlikely that this director honestly believed it did, but underlines the ultimate test is as to compliance with this section is a subjective one. Now, that brings me to the point put to me by my Lord Justice Snowden, who will say, well, those authorities are all very interesting, but they don't quite answer my question. And my Lord would be right, they don't. The answer to my Lord's question is this. If a director genuinely believes that, so to speak, the ends justify the means.
Right. Can we just take the word genuinely out for a second and just use the word really believes, actually believes?
Oh, yeah, okay.
Yes. Simply because when you say either sincerely or genuinely, it sort of begins to float towards honesty. So if we just... you're saying is...
In fact
believes.
Yes, in fact, yes. So I was only using the words because that came from Mr Justice David Richards.
No, I can see that.
Yeah. If a director in fact believes that the ends justify the means in relation to his conduct of the company's affairs, and those means were what the ordinary man, or whatever we're going to call the objective person, would regard as disreputable or underhand, I'm paraphrasing my Lord, but I'm not seeking to change the question, we submit that that is not a breach of 172. I hope I've answered that question very clearly.
Okay, you have. So
now,
what you're saying is you can behave in a way that ordinary people would regard as, let's not mince words, dishonest. But because you actually believe it's in the best interest of everybody in the long run, you're not in breach of fiduciary duty.
Yes, and you actually believe it's in the best interest of everybody in the long run, and that actual belief is held in good faith. I mean, I'm not seeking. I know my Lord didn't want me to put it in, but I'm not seeking to minimise what I'm arguing, because in 172 I have to recognise I'm coming to this point that in good faith is in the statute.
Yes, it's just in slightly different place than Mr. Justice Jonathan Parker had put it, or at least some of the other authorities did.
I really will say it now. It's in absolutely the right place for Mr. Justice Jonathan Parker. It's in the wrong place, if I may say, from the point my lord is putting to me, and let me explain why.
Okay.
And I don't want to be any misunderstanding as to my submission. My lord has put a direct point to me, and I hope I'm answering it directly. The only objective part of 172 goes to, so to speak, the evidential point, which is what I've been calling the last sentence of Mr. Justice Jonathan Parker. The more you're asserted, the more the director's asserted honestly held belief departs from what an honest and reasonable person would otherwise have done or believed, the less likely it is that he or she will be able to persuade the court that that in fact was their actual honestly held belief. But first of all, when one looks at 1721, which is what we ultimately have to apply here, because 1721 codifies the common law test.
Yes, it doesn't. I think the common law, okay, codifies it, but there is something in.
That's at tab 2 of the authorities manual at page 90, at page AB9. And in my submission, the point I've made is does not only follow from the authorities which explain that the test is subjective, it also emanates from the way Parliament has codified and or imposed this duty. Because it's a director of a company must act in the way he considers in good faith would be most likely to promote the success of the company. It's not a director of a company must act in good faith in the way he considers would be most likely to protect the success of the company. Right. Now, that is a really important distinction on my case.
It's a really important point.
It's a really important point.
If, as I understand it, what you're saying is, if you have a fiduciary, the director is a fiduciary, the defining characteristic of a fiduciary is the duty of loyalty.
Yes.
So you have to act with undivided loyalty to your principal. So a director has to act with undivided loyalty to his company. And you're saying it's perfectly okay to fulfill that duty for a director to say, in order to serve the interests of my principal, my company, I'm prepared to act dishonestly and commit a criminal offence because the end justifies the means. And I'm being perfectly loyal to my principal, and so I can lie and cheat and thieve because I genuinely think, I really think, that it'll be in the best interests of my principal. And you're saying that's fine, that's not a breach of fiduciary duty. There is no underlying overriding duty of a fiduciary to act either honestly or otherwise. I mean, I think you have to go that far, don't you?
Well, I, for the purposes of this case, I have to go so far as to say that's not a breach of 172.
Okay, well, but 172 is undoubtedly a fiduciary duty.
Yes.
And the same principles. I mean, in fact, directors and companies are the most common fiduciaries up and down the country. So, it's a pretty big point.
I wasn't seeking to quibble with my lord on that point, in the sense I wasn't seeking to avoid the point my lord's putting to me.
Yeah.
But I do want to emphasise that the point I'm putting is that it wouldn't be a breach of 172. It's not a breach of 172 to say to yourself, I know that left to itself, my principal, if we're talking about sort of an agent fiduciary, or my board of directors, if we're talking about a company, is going to take a decision which actually is utterly catastrophic and stupid. But I know they're going to do that because I just know that in this case, that is what they're going to decide. I'm not going to tell them the whole story, and I honestly believe that that is in the best interest of everybody, the shareholders, the directors, everybody. Now, the more to pick up the Jonathan Parker point, if I can respectfully call it that, the more egregious your conduct, the harder it's going to be to persuade a court that that's what you honestly believed at the time. That's the Jonathan Parker point. But if you do persuade the court that that is what you actually, in fact, believed at the time, that, in my respectful submission, fulfills the duty, or certainly doesn't breach the duty in 172. And it would have been the easiest thing in the world for Parliament to tie the good faith to the action. And it doesn't.
Do you accept that before 2006 there was a freestanding, the duty of the fiduciary could have been expressed as to act honestly in what they believed to be the best, subjectively believed to be in the interest of the company? Did the requirement for honesty exist separately prior to 2006?
The short answer, my lord, is I don't know.
Because before you answer the question, and it's very wise you probably didn't, you then have to look at section 170, subsection 4, which isn't in the bundle.
Yeah.
Because that says, it's the section that, actually I don't think it's in the bundle.
I don't think it is, my lord.
No, because what that does is it precedes section 171 and 172. It says, the general duties specified in sections 171 to 177 are owed by a director of a company to the company.
Yes.
And then sub 4, the general duties are, sub 3, okay, the general duties are based on certain common law rules and equitable principles as they apply in relation to directors and have effect in place of those rules and principles as regards the duties owed to a company by a director. But then 4, the general duties shall be interpreted and applied in the same way as common law duties or equitable principles. And regard shall be had to the corresponding common law rules and equitable principles in interpreting and applying the general duties.
Yes.
So when we are looking at what 1721A means, we are directed to have regard to the pre-existing
Yes. I respect
rules and equitable principles. So I don't think section 1721A is intended to have changed the law in that respect.
Well,
it's not obviously.
I was going to agree with everything my lord said until that very last point, because what 170 sub 4 says is two things. The duties, i.e. the 172 duty for present purposes, is to be interpreted and applied in the same way as common law rules or equitable principles. Now, it's to be interpreted and applied in the same way, and regard shall be had to the corresponding duty in interpreting and applying the general duties. What it certainly is not saying is it's the same thing, because it's only regard shall be had in interpreting and applying. If it's the same thing, it's not regard shall be had. And we all know Parliament, when it says regard shall be had, is saying something less than and different to this is the same as that. It's certainly saying regard shall be had, but certainly, I was going to put it this way. There isn't a case in the bundle, as I understand it, nor's my own friend produced a case, in which a director who was found to have, in fact, honestly believed that what he was doing was in the best interests of the company, but who was engaged in nefarious conduct
to achieve
to that end, that's the shorthand, has been held to be in breach of 172. Now, I appreciate you might say, well, that's an argument from silence, but there's certainly no authority, in my respectful submission, against my proposition. And in my respectful submission, it is rooted in two things. First of all, in what this test is and is said to be all the time subjective. The only objective basis is the more egregious your conduct, the less likely you'll persuade a judge of the Chancery Division that you were in fact honest. And the other point is the way in which Parliament has chosen to enact 1721. And that, in my respectful submission, is very, very clear.
How does that point that the director can do whatever he likes, provided it's genuinely in the interest, he believes in the interest of the company, how does that square with the sub-paragraphs of 1721, including E, the desirability of the company maintaining a reputation for high standards of business conduct.
Yes, and you've got to have regard for that. And
acting dishonestly would not be within the high standards of business conduct, would it?
it may not be in the high standards of business conduct to breach a contract. But it simply doesn't follow, in my respectful submission, that a director who says to the board, actually, we should breach his contract, will breach his contract and pay damages. That's what we should do. That's in the overall interest of the company. Now, that might be good, bad, or indifferent, but in my respectful submission, it would never be regarded necessarily as a breach of 172, even though breaching a contract would often not give you a reputation for high standards of business conduct. These are all have regard to. The central feature underlying all of this is what the director subjectively considers in good faith.
And is there any evidence that Mr Costa did have regard to the things in subparagraph E and F?
Well,
and if not, what's the consequence of that?
Well,
bearing in mind the statute says he must.
The short answer to that, in my respectful submission, is my learned friend is bringing the case on this basis as he acted in breach of 172. Mr Costa was cross-examined for 4 days. If there is, so to speak, no evidence on the point, then my learned friend has not established breach. I don't mean to evade my Lord's question, but that is my answer to it.
So the logical consequence of the proposition you're inviting us to accept is that if notionally, not this case necessarily, but notionally, a director defrauds the company by dishonestly making a false representation in order to induce it to do something that it wouldn't otherwise do, because they believe that in the long run it will be profitable for the company, that's fine as far as Section 172 is concerned, although it might well be a crime against the company.
Yes. My Lord, again, I don't wish to quibble. My Lord used the word defrauded. I mean, certainly, if...
I was thinking of criminal offences.
Yes. Is my Lord's point the same if we use the word deceive? So, yes. I'm just hesitating on defrauding because it might be heard as for putting the money in my own pocket. And of course, that would be... Yeah.
Fraud by misrepresentation or abuse of position under the 2006 Fraud Act.
That's what I exactly. So I was just using the word deception as a shorthand. Yes. Yes, my Lord, that is the consequence of my argument. Yes.
So it'll be in the interest of the company to not pay so much tax because we need the money, and so I think it's appropriate to make a false return to the revenue. That's in accordance with the director's fiduciary duties.
At that level, it's going to be, I mean, given that the company is going to be committing a criminal offence, your chances of
persuading... People get away with it. Because I genuinely believe I'm going to get away with it. I'm really good at this.
Can I give a slightly different example? Because I think at that level, you're always going to fail Jonathan Parker's rider. But can I put it this way? The company's got to pay tax by the 5th of April. If the company doesn't pay tax by the 5th of April, it has to pay interest on that tax at 5%. The director says, actually, I'm able to get the company a 6-month investment, rock solid, at 8%. So I'm not going to tell the board, we're going to put the money into the 8% bond, the gilt, we're quids in. We're quids in. Now, again, that is an example of criminal conduct. So you're going to, so to speak, have trouble with what I'm calling, without any lack of respect, I hope, the Jonathan Parker rider. But if you can get over the Jonathan Parker rider, you don't fail 172 for any other reason. That is my submission.
Okay. So could you just, I've got one last question then. I mean, the locus classicus of directors' duties prior to 2006 was Lord Green in Smith and Fawcett, which is 1942,
Yeah.
Chancery 304, and he says this: the directors must, they must exercise their discretion bona fide in what they consider, not what a court may consider, is in the interest of the company. So he put the bona fide in, I think, a different place.
Yeah, except if I may say, saying you're going to exercise your discretion bona fide, that actually begs the question.
Well, no, but it's critically, they must exercise their discretion bona fide in
what
what
they
consider, not what a court may consider, is in the interest of the company. And that's what I always thought the formulation was. So in other words, you must act bona fide in what you, the director, not what somebody else thinks, is in the interest of the company. But that seems to have been translated into putting in good faith into a, after the word considers. And you say it has affected a significant change to what I suggest Lord Green probably thought.
Well, the first part of my answer is that I was submitting that as I would read what Lord Green said in Smith and Fawcett, is not necessarily, in my submission, it isn't what he was saying. When he was saying must exercise his discretion bona fide, it's the exercise of the discretion which must be bona fide. It's not saying that the actions you do must be actions which people would regard as honest.
Well,
point one. Even if I'm wrong about that, then I do have my second submission, which is that is not what Parliament has set out in 1721. And of course, you have to have regard to the previous authorities. And on this, I'm assuming that I'm wrong on the first point I've made. Mm. Even if you have to have regard for them, when Parliament has very clearly, in my respectful submission, done something different, you can't simply say, well, Parliament has missed it or got it wrong or anything else. Again, I don't want to give evidence on it, but the 2006, as we all know, Companies Act didn't just come from anywhere. I mean, the 2006 Companies Act was the product of the previous reports and all the rest of it. I mean, everything, of course, that Parliament does is subject to the utmost consideration and fine judgment. We all know this. But can I put it in this way, that the 2006 Companies Act is really Parliament thinking about it, because there were some heavyweights involved. So it really goes to my point that even if I'm wrong on the first point I submitted, this court, with respect, is circumscribed by the way Parliament has chosen to do it unambiguously, I would submit, in the first section, the first sentence of 172. Now, the other point I was going to make, and I don't know how much I need to do this, is to say, I was going to make the submission that it's not surprising that the judge found no breach of 172, even though Mr Costa had misled the board, because by this stage, everybody thought that everybody else was a bad actor, and the relationship had totally broken down. So in those circumstances, the judge, who had the benefit of seeing Mr Costa in the witness box, cross-examined for 4 days, he was perfectly entitled to come to the conclusion he did, and we say he very clearly did in 208. And I would say that is particularly the case for a judge who showed no hesitation in, if I can put it demotically, throwing the book at Mr Costa in other parts of the judgment. I mean, this is a judge who was very severely critical of Mr Costa. But on this point, he finds that Mr Costa sincerely believed, which we submit as a gloss in the sense of Mr Justice David Richards genuinely believed. He, in fact, honestly believed he was acting in the best interests, and what he regarded as the best interests of the company and its investors.
Well, the difference between honestly and sincerely is that it's now very clearly established, and probably has been for a long time in Ivy, that the test for honesty is not just purely subjective, whereas the test for sincerity almost certainly is.
Yes.
Does that matter to the judge's expression of finding?
Yeah, it's certainly the case, and I thought, if I may say with respect, that my lord would be focused on this point. It's certainly the case that the move from gauche to Ivy is a different formulation. In other words, I'm gauche here. For the purpose of the transcript, that's G-H-O-S-H. Otherwise, that'll end up in the lawyer.
We're looking to use Photoshop on that transcript.
Exactly. Yes, Hansard can be corrected. I hope the transcripts can as well. But yes, I'm submitting that 1721 is gauche, if I can pick up my Lord's point and take it that way. So it may be better to use phrases like, the director in fact subjectively believed. And the question whether the director is acting objectively honestly or not only comes in 172 for what I'm calling the Jonathan Parker second sentence. I hope that answers my Lord's point.
Yes, thank you.
I'm sorry, my Lords. I'll come to that later. Just to pick up the point that everybody had fallen out. One of the points which the court will have picked up is right at the start of the judgment. One of the points the judge clears off the table in the pre-penultimate sentence of paragraph 4 is that although both sides thought the other was involved in some nefarious scheme, in fact neither side was, and the judge clears that off the page. So again, that ties into the judge's conclusion on this point. Would the court just give me a moment? I think maybe there's only two other points I need to pick up. Again, I'll deal. I think I need to say these 2 points. There is a point in my learned friend's skeleton that the judge's conclusion as to Mr. Costa's state of mind was, quotes, unsupported by evidence, close quotes. We frankly regard that as astonishing in circumstances where we heard live evidence for 4 days and where the factual issue is what is the state of Mr. Costa's mind. Not only with respect to this court is the judge the best placed person to draw that factual finding, he's the only person who can draw that factual finding. The other point I should pick up is the point made by my learned friend yesterday, and it's in his written argument at paragraph 27, that the judge's finding is somehow inconsistent with Mr. Costa's case at trial, that his co-directors knew what he was doing and approved his actions. Now, again, there is a subtle forensic sleight of hand here. It doesn't follow from the judge's finding that Mr. Costa misled the board that he wasn't acting or didn't in fact believe he was acting in the best interests of the company. That's the 1721 point. Mr. Costa's case, of course, was that he did believe the company was not ready for sale, and it was in the company's interest to delay a sale, and also that the other directors shared his view. That was his case. He wasn't submitting because the board knew what I was doing and approved my actions, therefore I'm not in breach of 172. That wasn't his case. So the fact that the judge has held that Mr. Costa misled the board but still had that subjective belief is not an inconsistent finding, certainly not inconsistent with Mr. Costa's defence. Now, if, my lord, you're against me on this point, in other words, you're with me on the contract points. If you're against me on the contract points, then we get into the second trial, so to speak, anyway. We can debate the counterfactuals, but we're going to be there. If you're with me on the contract points, but against me on this point, which my learned friend now puts forward as a separate ground of prejudice, my respectful submission, the correct approach would then be to remit the question of relief to the judge, since he simply didn't consider this form of prejudice when he ordered the buyout. That's all I was going to say on 172. But I hope I hope I've answered what I did identify as the pivot point, which is the point put to me by my Lord Justice Snowden. On 174, I can be a lot briefer, because the learned friend, I think, essentially accepts that he's not going to get a buyout order if all he has is 174. I'm not sure he accepted that in terms, but being the realistic advocate that he is, I think that's where we got to. In any event, although my learned friend yesterday took the court to the pleadings, in terms of the closing argument from a learned friend, which is in the supplemental bundles at tab 54, which we don't need to turn up. I was only going to turn it up just to remind myself how long it was. These were something of War and Peace closing submissions. It's about 150 pages. Section 174 gets a page. So I think it's fair to say it wasn't the forefront of his argument before the judge. It was also based on the incorrect premise that Mr Costa was pursuing some transaction other than an exit. And again, I'll just give the court the reference. That's from the written closing, the page where it's dealt with, 986, supplemental 54 at 986, paragraphs 514 to 515. That was the case theory that Mr Costa never intended to sell the company. That's the case theory which, as I said a moment ago, the judge rejected, both in general terms at paragraph 4 of the judgment and in more detailed terms at paragraphs 164 to 166 and 218. So, my lords, I think that was all I was going to say on 174. That deals with grounds 1 and 2 of my learned friend's appeals. Now let me turn to grounds 3 to 6, which I'll deal with individually, but there is an element of overlap. And let me first identify what the overlap is and say a word about the order of ICC Judge Burton. Grounds 3 to 6 are all directed towards issues of prejudice and relief. And the learned friend's essential submission here is that Saxon Woods has been hard done by because instead of ordering an unconditional buyout at whatever price the shares were valued, the judge ordered a buyout if, but only if, Saxon Woods can prove at trial 2 that an offer in excess of 75 million would in fact have been received. Now that is, with respect, a bold submission in circumstances where, having heard all the evidence at trial, the judge was unable to conclude that Saxon Woods had in fact suffered relevant prejudice. Now, learned friend took the court yesterday to the language of the judgment and the rather long, somewhat unusual letter from Stevenson Harwood requesting clarification of the judgment and the consequential judgment. But my learned friend did not take the court to the most important paragraph of the consequential judgment, which makes crystal clear that the judge was not satisfied that Saxon Woods had in fact suffered prejudice, and that's 56 of the consequential judgment, which is at core 303. I've concluded the petitioner suffered unfair treatment. I don't know whether he has in fact suffered any material prejudice or not. These circumstances would be rather odd to make an order that started off by assuming that prejudice had been found and granting a buyout remedy consistent with that finding. So I don't think the appropriate order, even at this stage, is, as learned friend suggests, a simple buyout order subject to a contingency. Consequently, will have to be in the form of a direction to the trial judge for the quantum trial to make a buyout order if the conditions for making it turn out to have been satisfied. Now, I absolutely accept that the paragraphs, or some of the paragraphs, which learned friend took the court to from the first judgment about whether he had found prejudice or not, were, with respect to the judge, both confused and confusing. He did say in his first judgment that Saxon Woods had suffered unfair prejudice. He used that phrase, but as this paragraph makes clear, what he actually meant was unfair treatment. Because this is his, so to speak, 56 is his second and better attempt to summarise what it is he's found. And he's saying in 56, in terms, I've not found prejudice.
Or is he just misdescribing what he has found?
Well,
I mean, this is the problem with... It happens so often. You get referred, for example, to what the judge says when refusing permission to appeal as to what they thought they've decided.
yeah.
How do we deal with this?
Yeah. I'm afraid I'm going to be very unhelpful and say what the court has to do is to look at all of it in the round. I think Lord Sumption once gave a lecture when he said these phrases are really an attempt by counsel to leave it entirely to the court. But more seriously, when a judge is considering whether to give permission to appeal, the judge is necessarily massively telescoping what the judge has actually found in his judgment in order to fill in the form. We know what we mean, the form, where you don't get very much space. And really, the focus of the trial judge, as with great respect, the focus of now the single judge without any oral hearing ability in the Court of Appeal, is really to summarise why you either are or are not giving permission to appeal. This wasn't what was going on here. The letter written by Stevenson Harwood was a letter, frankly, the likes of which I've not seen before. I'm not criticising it. I understand why they wrote to the judge in that length. I've never seen a letter like that before. And certainly, as my learned friend said, what they were inviting the judge to do was please clarify what exactly you've decided. What the judge was doing in the consequential judgment, and again, as my learned friend said yesterday, I've also not seen a consequential judgment at this length and in this detail. This is really it's a coda or a clarification of the main judgment. And when we want to see what the judge has decided, having sat down with his judgment, no doubt, and with the benefit of the Stevenson Harwood letter, what the judge has said...
So just to be clear, the letter was before the final judgment. So the judgment was written with the benefit of the letter.
That's fair. That's fair.
I think it provoked paragraphs 261
it did.
and 262 in the original judgment.
It did. That's absolutely fair. That's absolutely fair. But then there was clearly, and we've got I think all of the transcript, we've got quite a lot of the transcript of the consequential hearing. Certainly the consequential hearing, there, obviously I wasn't there, but from the transcript there's a big debate as to what on earth has been found and where are we going from here and why. And this is what the judge does in the consequential judgment at 56. And
Is this an extempore?
no, it wasn't, as I understand it. I think the learned friend confirmed.
Beg your pardon, I'm so sorry. This followed the consequential hearing where applications for permission to appeal were made and there was a discussion about the consequential.
And the judge reserved his consequential judgment.
That's right, my lord.
And issued it in writing.
That's right. My learned junior clarifies there was an extempore judgment at the hearing, but then this further written judgment followed afterwards.
Yes, thank you.
I think, so for present purposes, this was a, so to speak, reserved consequential judgment, if we can call it that. So that is the submission I make, that I absolutely accept that the first judgment, both, so to speak, in draft and then as finally promulgated, is confusing. But it is clear, my respectful submission, what the judge is saying in 56 of the consequential. Now, I would also accept, with respect, the point put yesterday by my Lord Justice Zacaroli. You can actually analyse this in one of two ways, but I think for present purposes you get to the same result. You can either say there's no prejudice because an exit wouldn't have happened in any event, or you can say there was prejudice because Mr Costa caused the company to breach its obligations, but no consequence flows from it as a matter of relief unless you can show it has causative effect. To put the whole thing more demotically, one way of summarising it might be to say, do any of these breaches actually go anywhere? That's really what the judge, if I can submit it that way, was saying. Now, if I was to be asked to choose, in my respectful submission, the former analysis is preferable. There's no, if an exit wouldn't have happened in any event, there is no prejudice. Certainly on the contract point. Now, the need to prove prejudice and a causal link between that prejudice and the conduct complained of are central elements of section 994. Indeed, I don't think that really is in dispute. It's clear from 994 itself. It's clear from a number of authorities. I'm just going to cite one for the court's note. Southern Counties, Fresh Food, Authorities, tab 24, paragraph 47. There must be a causal link between the conduct complained of and the unfair prejudice suffered by the shareholder. And a number of authorities have been cited for that proposition. Now, if the judge had been perhaps in a stricter mood, the judge might have said, well, we've had a trial. The only question left over by ICC Judge Burton in his split is the valuation question. What are the shares worth? If you haven't proved that actually any of this goes anywhere, that's the end of the case. You haven't discharged your burden of proof. And on a strict analysis, we do submit that ought to be really the end of the petition and certainly of the learned friend's appeal, that if they'd failed to prove prejudice. Now, the reason why I mention ICC Judge Burton's order is because this is a point which the judge deals with in the consequential judgment at paragraph 40, where perhaps picking it up first at 39, page 295, we see my learned predecessor's submission is that there's no basis to find unfair prejudice. And the petitioner couldn't have shown it had suffered detrimental prejudice if it couldn't demonstrate a final offer would have been made at a level the shareholders would have accepted. That's a 75 point. There was no evidence before the court that would have enabled a determination as to whether an offer at that level would have been made. He, Mr Hill, Casey, therefore argues that following Rock, I should have found the petition not satisfied the burden of proof. I should have dismissed the petition. 40, there'd be something in this if I'd had valuation evidence before me and found it insufficiently probative. But questions of valuation were deferred to the quantum trial. That meant expert evidence was limited to questions of investment banking practice. Experts were instructed not to and didn't address issues of valuation. I think the argument I should have dismissed the petition has no chance of success. Now, it's also clear that that is the only basis on which the submission was rejected. That also ties into my submission that the judge wasn't satisfied that Saxon Wood had suffered prejudice as a result of Mr Costa's conduct. But what the judge did here was, in my respectful submission, to misapply. Of course, he has jurisdiction to do anything. I mean, the judge can remake the order. But he did misapply, my respectful submission, what the order says. Now, I don't know whether the order of ICC Judge Burton is actually in the bundle. Let me just hand, can I hand copies up to the, I need another one. Can I hand them to the court? My lords, it's always the case that when there is lots of stuff in the bundle which isn't relevant, a document which is not in the bundle. And I'm not sure whether this arises on my appeal or my learned friend's appeal, but as I'm relying on it, I'm going to apologise. This is the order of ICC Judge Burton, and the relevant paragraph is paragraph 11, under liability trial date on page 4. The issue of unfair prejudice and, if unfair prejudice is proved, the issues of whether relief should be granted and the form of relief to be granted, including what adjustments need to be accounted for in any valuation of the petitioner's shares, taken together the liability issues, to be heard separately from and prior to the question of the valuation of the petitioner's shares. So the only question held over was that how much are their shares worth question. that is a quantum issue in the purest sense of the word. You only get to it if and only if liability is established. So what the trial judge held over was well beyond what was held over by the Burton order. And we can test it in this way. Imagine that moments before the consequential judgment was handed down, the parties knocked on the judge's door in chambers and said, Judge, to help you out, we've agreed that at the time the company was objectively worth $82 million. The question of valuation falls away. Coming back to a point which my Lord Justice Snowden made yesterday, it doesn't follow that that would have answered, it would not have answered the questions which the judge was unable to answer at the end of the trial, which was one, would anyone in fact have offered $82 million on a binding basis? The fact that I own a house worth £500,000 doesn't mean that somebody's going to offer me £500,000 for it, even if I put it on the market.
Well, if nobody does offer you, or would offer you £500,000 for it, there's an argument it's not worth that.
I agree. I'm not saying there's no relationship between the two. Of course there's a relationship between the two. I'm just saying that if the parties had come in and said, we agree objectively, this is what the shares are worth, it doesn't necessarily and clearly answer the judge's question, would anyone have offered 82? It also doesn't answer the question, would the shareholders in fact have accepted 82? Of course it's a relevant factor, absolutely. But it's a different, conceptually, it's a different question. And so what the judge was doing, in my respectful submission, was holding over to what I'm calling trial 2 more than ICC Judge Burton anticipated being held over to trial 2. And that's especially in the case where, as we've seen when I showed the court the petition, paragraph 72 of the petition pleaded in terms of the causal link between Mr Costa's conduct and the prejudice in but for terms. But for that conduct, an exit would have been achieved by or shortly after the 31st of December 2019. A proposition which, again, for the court's note, was put squarely in issue by the re-amended defence at paragraph 74, which said an exit wouldn't have been achieved in any event between the expiry of the investment period. So what should have happened, in my respectful submission at trial 1, was that evidence should have been led which answered the judge's questions. Now, that is relevant to this extent. I can't, Lady Justice Asplin has not given me permission to argue in terms that the judge should have just dismissed the petition. And if I'd received Lady Justice Asplin's order under, so to speak, the old regime, I would have had an opportunity to persuade the Court of Appeal orally that this is a point which, if I'm right on it, so to speak, it's a so to speak, a killer point. I can't do that. I'm bound by it. So how then is it relevant to this appeal now? It's relevant to this appeal because it's a very relevant factor, because there is no basis, we would say, to allow Saxon Woods a relief now on a unconditional basis in circumstances where the judge has actually been generous to them in giving them relief on a conditional basis, because really they didn't prove their case at all, because they hadn't proved prejudice, and prejudice was what they actually had to turn up and prove at the first trial. So they shouldn't be given a second bite at the cherry in terms of either unconditional or a second trial with more relaxed parameters than the ones the judge imposed. We say the judge has been too stringent on us. The parameters certainly should not be more favourable to my learned friend. Now, with that, and it's important because that point, so to speak, shapes the whole of grounds 3 to 6. Let me turn to ground 3, which is the correct approach to relief under 996. Malone Friends' appeal in relation to prejudice, therefore, we say with respect, must fail because it's based on a fundamental error. The error being that the judge has held that Saxon Woods, in fact, has suffered some prejudice. The basis of Malone and Friends' criticism of the judge and of the judge's approach in ground 3 of Malone and Friends' appeal is that because the judge held that we had suffered prejudice, his approach thereafter was wrong. That's essentially the submission made in writing in yesterday. It's in writing at 46 of his written argument, 49 of his written argument. What the judge was doing was actually asking the question, well, has prejudice been suffered at all? And what the judge was doing, importantly, is to ascertain, this is a very important point, the judge was doing no more than holding the learned friend to the particular prejudice which he'd pleaded. The judge was trying to answer the question, has Saxon Wood established what they pleaded at paragraph 72 of the petition, which is, but for that conduct, an exit would have been achieved before the expiry of the investment period, alternatively early in 2020. And the reasoning is made clear again in paragraph 24 of the consequential judgment, where the judge referred to Malone and Friends' submissions, which have now obviously taken a much bigger part of the way he now wishes to present his case on appeal. But as the judge identified, wasn't his case before. The first point made was the Grayson Zacaroli point, i.e., why should I have to stay in bed with people who act like this, essentially? If this happened before, it's going to happen again. A point impressed on the court yesterday by Malone Friend. 4 lines down, that is not the case here. Mr Davis sought to identify other aspects of prejudice which the petitioner suffered. These seem to me to be de minimis. The basis of his case was squarely presented, and I would submit as pleaded, as the petitioner's having been deprived of the opportunity to exit. And then goes on, the obligation wasn't to exit but to solicit offers. Opportunity to exit would only have arisen if all shareholders had been prepared to accept a solicited offer. So to answer paragraph 72 of the petition, there wouldn't have been an exit unless an offer at a level acceptable to the other shareholders would have been received. The judge found the threshold for an acceptable offer was over 75 million, and the condition therefore placed on relief by the judge on the buyout order, i.e. there must have been an offer in excess of 75 million, square brackets, not that the company must be worth more than 75 million, close square brackets, has nothing to do with the appropriate relief for the unfair, that is the relief fashioned to Malone and Friends' case. And the condition, therefore, has nothing to do with the appropriate relief. It's all to do with whether there was, in fact, prejudice at all. I hope I've now said that clearly. The judge was not satisfied that prejudice had been suffered at all. There would only have been prejudice suffered if Malone and Friend can show that an offer above 75 would have been received, because only in that respect does he come close to his pleaded case. And in this context, especially, frankly, when you've got a petition which is as long as this one, it's quite right to hold the petitioner to the pleaded case. We rely in this context on some remarks of this court in a case called In Re G&G Properties. It's in the authorities bundle at tab 38, at paragraph 35. I don't need to read it out, but it's, to summarise, the court endorses a submission of Mr Daniel Lightman, QC, emphasising the importance of a proper pleading of the petitioner's case in a claim under section 994. I fully endorse that approach. The breadth of the court's jurisdiction in such cases makes this essential, both so that respondents know the case they have to meet, and so the court can keep the proceedings within manageable bounds. And we say the same applies here. Now, I accept in this context, as I think I accepted earlier in response to my Lord Justice Snowden, that prejudice does not have to be financial in character. But there are 2 points. First, the judge didn't conclude that prejudice had to be financial loss. The judge didn't say, I'm not going to look in principle at any prejudice which is not financial loss. He concludes that the pleaded prejudice, which is failure to exit, would only have been avoided if an offer in excess of 75 million had been received. So to that extent, my learned friend is shadow boxing.
I mean, what he actually says is there would be no loss suffered if you didn't get an offer over that amount. I mean, I know I don't want to go back over the old ground, but if you look at paragraph 254 of the judgment, which is where he tees up there's going to have to be a quantum trial.
Yeah.
He's actually talking about, he says, if the company performed its contractual obligations, it would have had at least 1 or 2 conditional offers on the end of the table by the end of the investment period. If it had properly instructed Jefferies, it might well have had more.
Yeah.
The extent of the loss suffered by the petitioner as a result of the unfair prejudice which it has suffered is therefore, to my mind, simply a function of the value of the best offer which the company would have received. There'll therefore have to be a quantum trial to determine the value of such a hypothetical offer. I mean, I appreciate you say that's not consistent with what he said subsequently, but I mean, that's what he thinks that the quantum trial is there to determine, isn't it?
Yeah, yeah. I mean,
you know, so it is that does lead through to his sort of question about, well, if the best offer that would have been received would be one that wouldn't be required to be accepted, then no loss.
yes. I accept that all roads here lead to Rome in that sense. I absolutely accept it. And this may turn on the point identified, which I sought to address earlier from my Lord Justice Zacaroli, as to how you categorise this. And that ultimately, the way that point is decided as a matter of jurisprudence might be well above my pay grade. But ultimately, for the purposes of this case, all roads really do lead to Rome, because whichever it is, if it's that you suffered prejudice, but you shouldn't get any relief unless you can show there would have been an offer, or unless you can show there would have been such an offer, you've not suffered prejudice. For the purposes of this case, for my case, all roads lead to Rome. I hope I didn't duck it. I identified which I thought, with respect, was the right answer. But I certainly agree with my Lord Justice Snowden that the purpose of the second trial is to tease out that point. It's not a valuation point. It's not really a quantum trial. It's a point which, quotes under the Burton order, have been dealt with at trial 1. But in any event, that's where we've got to. What the judge is certainly saying, though, is if you, i.e. Saxon Woods, can't prove that, then, can I pick up it's just too tempting to leave the analogy just lying there, you leave the sweet shop empty. Essentially, that's what he's saying. That is the currency to get something in the sweet shop for the purposes of this case. And we can have a nice debate, I suppose, just take that a stage further, as to whether you're not in the shop at all, or whether you're in the shop but you're not allowed to buy anything. That might be the reformulation of my Lord Justice Zacaroli's 2 options. In my submission, you're not in the shop, but all I care is whether I'm paying for the sweets. Now, so the first point I'm on is that what the learned judge is doing here is saying that the pleaded prejudice, failure to exit, would only have been avoided if an offer over 75 had been received. And secondly, nowhere did Saxon Woods plead that disregard of its rights as a member of the company itself amounted to prejudice. Now, my learned friend Skeleton appears to assert the contrary at paragraph 47. I haven't seen where that is in the pleading. I may have missed it. But certainly my submission is that Saxon Woods didn't plead that disregard of its rights as a member of the company amounted to prejudice. And it's really unfair to criticise the judge for dealing with the pleaded case.
I mean, there is, I'm afraid, I suspect what will be put back to you is the age-old formulation that appears at paragraph 137 of the petition, and it's those great words. In the premises,
Oh, yes.
the affairs of the company, meaning, given what's gone before,
Yeah.
I mean, that's, I mean, I'm guessing, but I'm guessing that will be at least one of the responses you're going to get.
Yeah.
So that's the cut across that just now.
Yeah. I mean, there are two ways one could put this point. I wasn't putting the point in terms of, so to speak, it's not pleaded and therefore my learned friend can't rely on it, it is not argued. What we're dealing with here is my learned friend's criticism of the judge's approach to relief. In circumstances where, at best...
No, I just thought you said you'd searched and you just couldn't find it, and
Well,
I was just helping you along.
Well, I was putting it higher than it's put in 137. I'm not sure we need to have the debate about it, but certainly we say that this was not the way. This isn't the way it's put.
Yeah.
And it's certainly not put there that disregard of its rights as member itself amounts to prejudice. But in any event, I'm not taking, so to speak, that narrow type of pleading point. This point arises in relation to ground 3, because ground 3 is my learned friend's point that the judge has adopted an incorrect approach to relief. What I'm saying is the judge dealt with the case essentially as pleaded, as presented, as argued. And that's clear from the passage in the consequential judgment and the passages in the main judgment, which I've taken the court to. And to be clear, in my submission, it's clear from what the judge is doing that the 75 million threshold doesn't really go to 996 relief. In my respectful submission, the judge is saying it's going to 994 liability.
Well, it's both, isn't it? Because it then fixes the value.
Oh, sorry. Yes. It's either, logically, it's either 994 and 996 or only 996. It can't be only 994. I respectfully agree. My learned friend's submission is it's only 996. My submission is no, it's certainly part of the judge's approach on 994. Ground 4 is that the judge gave insufficient weight to or misunderstood the prejudice suffered. And, of course, by ground 4, and really in contrast to ground 3, Saxon Woods appears to recognise in ground 4 that the judge concluded that prejudice had not been made out at trial. And the essence of this is the claim that the judge somehow misunderstood the prejudice suffered, which is now said to be the disregard, picking it up from a learned friend's written argument at 56, the disregard of Saxon Woods' rights under clause 6.2 of the Shareholders Agreement, the consequent loss of the opportunity to exit by the end of December 2019. And on this basis, he says, whether a binding offer would have been made is irrelevant to the question of prejudice because, and to quote him at 57.1, it is sufficient that there was at least a realistic possibility that an offer could have led to an exit. Now, I've already showed, my lords, the way it was put in the petition, which is on a but-for basis. I mean, it couldn't be clearer. The petition argument is but for the breaches, an exit would have been achieved. That's a classic way of pleading balance of probabilities, 51-49. And there was no misunderstanding, we submit, on the judge's part as to what the case was. He addressed the pleaded case and dealt with it. And that really ought to be the beginning, middle and end of ground 4. Let me just say a couple of other words on it, though. First, it's plainly not sufficient that there was a realistic possibility that an offer could lead to an exit, because the burden is on Saxon Woods to show prejudice on a balance of probabilities. That's the way it was pleaded, and it's fatal if a petitioner is no worse off as a result of the allegedly prejudicial conduct. The burden was on them, they didn't discharge it. First point. Secondly, contrary to the way my learned friend puts it at 56.3 of his written case, the judge didn't hold that, but for the breach of 6.2, there would have been at least one binding offer by the end of the investment period. He held that there would have been one or two conditional, i.e. non-binding offers by that time. That's 254 of the judgment, which I think is the page we were just on. And indeed, that's how Stevenson Harwood read it in their letter sent to the judge after the draft judgment. Now, I accept that when we get to the final order, paragraph 1 of the final order contains an obvious drafting error, because if one looks at paragraph 1 of the order and then paragraph 3 of the order, they are really mutually exclusive. This is at core 12. Fortunately, none of this is now going to be a problem, because however this court determines these appeals, we can, so to speak, tidy this up. That Schedule 1, paragraph 1, is there would have been at least one binding offer for the company by the end of 31st December 2019. Now, if that's the case, there's a binding offer. 3, the company would have had at least one or two conditional offers on the table by the end of the 31st of December 2019. Now, when one goes back, we respectfully submit to the judgment 254, 5 and 6. The judge didn't actually conclude that there would have been a binding offer. Indeed, if there had been a binding offer, one would think that picking up the point made by my Lord Justice Snowden a moment ago, the work of the experts would be very much more simple and focused. And the court has my point, which I made earlier today, that the basis for these one or two conditional offers in paragraph 3 is itself the metric exit. Third, contrary to Malone and Friends' submission, neither clause 6.2 nor 6.3 gave Saxon Woods or any other shareholder the power to force an exit. I've made my submissions on 6.2. I've also dealt with 6.3. I may have a word more to say about 6.3 tomorrow morning in a point which we'll come to then. But we respectfully submit that the judge was right to dismiss the unpleaded argument based on Saxon Woods' supposed bargaining power. And essentially, the judge's approach on the basis of what he found to the question of relief was unimpeachable, and his approach was certainly consistent with his findings. My lords, that leaves me with grounds 5, 6, and then Learned Junior is going to address the court on 7. I might be able to do 5 in 3 minutes, if the court would indulge me.
Yeah, thank you.
And then we'll leave over the rest, if we may, for tomorrow. But of course, I've been doing, so to speak, my appeal and Malone and Friends' appeal. So.
Yes, my lord has to be elsewhere at 1:45, so we have only a short period of time.
Well,
do you want to have a go? And if you don't finish by the time we have to finish, you can pick it up in the morning.
My lord, I think it might actually be quicker. I've got that thing about, is it Pliny? I don't know. Is it Descartes or Pascal? Described to different people. I haven't had enough time to write a short letter. It might actually be, if the court will indulge me, if that's where we are, it might actually be quicker. If I look at my notes, I'll be able to do it quicker in the morning, I suspect.
I'm sure that's fine. Thank you.
Can I just add this 6.3? I think there was a question that we had on 6.3 this morning. I forget what it was.
No,
You're going to come back to it.
I'm going to come back to that as well. That's on my shopping list is ground 5, which is short, ground 6, which is short, Learned Junior on costs, and 6.3.
Yeah. Yeah. Good. Well, thank you very much. So, will we finish comfortably tomorrow if we start at 10:30?
I mean, between my submissions, so these submissions and whatever I would need to say in reply, if I have, so to speak, half the day, I'm confident I can do that. And Milan Friend has his half a day to make.
Fine. Thanks very much. Well, we'll do that then. So 10:30 tomorrow.
I'm grateful.
All right.